I watched from my kitchen window as the HOA president, Karen Hollingsworth, stood at the edge of what she thought was community property, gesturing wildly to a construction crew about where to place the first dock. Her blonde bob cut swayed as she moved, clipboard clutched in one hand, cell phone in the other. The lake behind my property in Hayward, Wisconsin, sparkled in the morning sun, completely oblivious to the chaos about to unfold over the next several months. My name is Xavier Thompson, and I had owned this property for 3 years. The house sat on 12 acres with roughly 800 feet of pristine lakefront on Mirror Lake. When I bought it, I knew exactly what I was getting. The previous owner, an elderly man named Gerald Hopkins, had walked me through every inch of the property lines, shown me the survey markers, and handed me a deed that was clear as day. But the Lakeview Estates, HOA, established 2 years before I moved in, seemed to have very different ideas about who owned what. I took a sip of my coffee and continued watching. Karen was now directing workers to mark spots along the shoreline. I counted as they hammered stakes into the ground. 1, 2, 3, 4. They kept going. 10, 15, 20. My neighbor, Richard Morrison, who lived in the development across the road, walked down to join Karen. He was on the HOA board too, treasurer if I remembered correctly. They both looked pleased with themselves. The thing was, 6 months ago, Karen had knocked on my door with papers in hand. She informed me that the HOA had voted to install community docks on the lake, and that my property would need to provide access. I had listened politely, nodded occasionally, and when she finished, I simply said I would think about it. She had smiled that tight-lipped smile that people like her always wore when they thought they had won, but I never gave permission. I never signed anything. I never responded to their follow-up emails or the certified letters they sent. I just went about my life, working remotely for a tech company in Minneapolis, enjoying my quiet lakefront property, and watching the HOA make increasingly bold assumptions. Now here they were, actually building the docks. The construction crew arrived every morning at 7 sharp. The sounds of hammering, drilling, and machinery echoed across the water. I watched them work for hours each day, expanding their project. By the end of the first week, they had installed 15 docks. By the end of the second week, 25. They were building a massive community marina, complete with boat slips, kayak launches, and even a small beach area where they dumped several truckloads of sand. My girlfriend, Emily Parker, thought I was crazy. She came up from Chicago that third weekend, took one look at the construction site, and immediately started pacing around my living room. "Xavier, what the hell? They are literally building on your property right now. Why are you not stopping this?" Her dark hair was pulled back in a ponytail and her brown eyes flashed with frustration. I set down my book and looked up at her calmly. "Because I want to see how far they will go." "How far they will go? They have already gone too far. This is insane." "You need to call the police, call a lawyer, call somebody." "I have a lawyer," I said. "We have been documenting everything. Every stake they hammer in, every dock they build, every dollar they spend. It is all being recorded." Emily stared at me like I had grown a second head. "You are purposely letting them do this. They think they have the right to do this. They think that lake access is community property based on some incorrect plat map from when the development was first planned. What they do not know is that the original developer lost that land in a bankruptcy proceeding 5 years before they even formed the HOA. Gerald Hopkins bought it at auction, and I bought it from his estate. I have a survey, a title report, and a property deed that proves every inch of that shoreline is mine. So you are just going to let them build this whole thing and then drop the hammer?" "Exactly," I said. If I stop them now, they will just call it a misunderstanding and walk away. But if I let them invest tens of thousands of dollars, maybe hundreds of thousands, and then prove they are trespassing, that sends a message. Emily sat down heavily on the couch. This is the most passive-aggressive thing I have ever seen. It is not passive-aggressive. It is strategic. She shook her head but could not quite hide her smile. You are either a genius or completely insane. Maybe both. By week 4, the HOA had installed 32 docks. Karen held a community meeting down by the water, which I watched from my deck with binoculars. About 40 homeowners from the development showed up, and Karen gave what appeared to be a very enthusiastic presentation. She pointed to the docks, gestured at the lake, and everyone clapped. Several people took photos. Some kids were already jumping off the docks into the water. Richard Morrison stood up and said something that made everyone laugh. A woman I recognized as Deanne Fletcher, another board member, distributed what looked like dock assignment papers. They were actually assigning specific docks to specific homeowners. The entitlement was breathtaking. My lawyer, Patricia Chen, called me that evening. Xavier, I drove by today. They have made significant progress. 32 docks as of this morning, I said. They are shooting for 40 total based on the permits I saw them posting last week. Permits they filed with the county claiming they own that land. Exactly. Patricia was quiet for a moment. You know, most people would have stopped this on day one. I am not most people. No, you certainly are not. Well, I have drafted everything we need. The moment you give me the word, we can file. I have to warn you, though, this is going to get ugly. They have invested serious money, and when they realize their mistake, they are going to come after you hard. Let them come, I said. I have been dealing with entitled people my whole life. Karen Hollingsworth does not scare me. It is not just Karen you need to worry about. It is the 40 families who think they now have lake access. When you pull the rug out, they are going to be furious. That is not my problem, I said. They should have done their due diligence before letting their HOA build on land they did not verify they owned. Patricia laughed. You have ice in your veins, Xavier. I just believe in property rights. The next morning, I woke up to find Karen Hollingsworth standing in my driveway. She was not alone. Richard Morrison and Deanne Fletcher flanked her, along with 2 men I did not recognize. I grabbed my coffee and walked out to the front porch. Good morning, I called out. Karen stepped forward, her face set in that familiar expression of barely controlled irritation. Mr. Thompson, we need to talk. Sure, what is on your mind? We have completed Phase 1 of the Community Dock project, and we need to discuss the access easement across your property. What access easement would that be? Her jaw tightened. The easement that allows community members to walk through your property to reach the docks. I do not recall granting any easement. The easement is implied, Richard interjected. The docks are for community use, which means there has to be access. I took a slow sip of my coffee. And you think that access goes through my property? Your property is between the road and the lake, Deanne said, her tone suggesting I was being deliberately obtuse. Where else would the access be? That sounds like a problem you should have thought about before building 32 docks. Karen's face flushed red. Mr. Thompson, let me be very clear. This community voted on this project. We have spent over $200,000 on these docks. The county has approved our permits. This is happening whether you like it or not. $200,000. I let out a low whistle. That is quite an investment. We have financing for the complete project. One of the men I did not recognize spoke up. He was wearing khakis and a polo shirt with a company logo. Another $100,000 for Phase 2, which includes the final 8 docks, a pavilion and parking area. And you are, I asked. Tom Sanderson, project manager for Lakeside Construction. We have a contract with the HOA. Nice to meet you, Tom. That is a lot of money. Karen crossed her arms. Mr. Thompson, we need you to sign the access agreement today. We have families who want to use these docks and they need to be able to get to them. I am going to pass on that, I said pleasantly. Excuse me, I am not signing anything. No easement, no access, nothing. Richard stepped forward. You do not have a choice. The community has rights here. Based on what? Based on the development plat filed with the county in 2019, Deanne said. She pulled out a folded paper from her purse. Right here, it clearly shows the lake access as common area. Can I see that? I walked down from the porch and took the paper. It was indeed a plat map, and it did show lake access marked as common area. It also showed property lines that bore no resemblance to reality. This is interesting. So you see, Karen said triumphantly, the lake access is designated common area. Designated by whom? By the original developer when the subdivision was planned. And did the original developer own the lakefront property when this was filed? Karen blinked. Of course he did. Are you sure about that? What are you talking about? Richard demanded. Michael Patterson owned all of this land. He developed Lakeview Estates. It is all part of the same property. Michael Patterson filed for bankruptcy in 2014, I said. He lost most of his assets, including the lakefront parcel, in the proceeding. That land was auctioned off separately and never became part of Lakeview Estates. The group went silent. Tom the contractor looked uncomfortable. Karen recovered first. That is ridiculous. If that were true, we would have discovered it when we did the title work for the permits. Did you do title work? Of course we did, Deanne said, but her voice lacked conviction. Really? Because I am looking at this permit posting on dock number 12, and I do not see any title company listed. I just see a county permit number based on your application claiming the HOA owns the property. The HOA does own the property, Karen insisted, or at least has rights to it. Show me the deed. What? Show me the deed that proves the HOA owns or has rights to this lakefront property. Show me an easement document, a title report, anything that actually proves your claim. Karen's mouth opened and closed. Richard and Deanne exchanged glances. Tom the contractor suddenly became very interested in his phone. We do not need to prove anything to you, Karen finally said. The burden is on you to prove otherwise. Actually, no. You are the ones who built structures on this land. The burden is on you to prove you had the right to do so. And when you cannot, you are trespassing. This is absurd, Richard sputtered. Everyone knows this is common area. Everyone assumes it is common area, I corrected. But assumptions are not the same as legal ownership. We will sue you, Karen threatened. For what? Not giving you permission to use my property. This is harassment. You are standing in my driveway uninvited, demanding I give you an easement on my land so that your HOA can profit from docks you built without my permission. If anyone is being harassed here, it is me. Tom the contractor cleared his throat. Folks, maybe we should all take a step back and get some legal advice before this escalates. Good idea, I said. You should definitely talk to a lawyer. Ask them about what happens when you build structures on someone else's property without permission. Karen pointed a finger at me. You are going to regret this, Mr. Thompson. This community does not take kindly to people who obstruct progress. Noted. Now if you will excuse me, my coffee is getting cold. I turned and walked back into my house, leaving them standing in the driveway. Through the window, I watched them huddle together in an intense discussion before finally leaving. Tom the contractor peeled off first, looking worried. The three board members stood talking for another 10 minutes before getting in their cars. Patricia called me an hour later. I just got a very aggressive call from the HOA's lawyer. That was fast. His name is Douglas Webb. He represents a lot of HOAs in the area, very combative, very sure of himself. He informed me that his clients have legal right to the lakefront property and that if you interfere with their dock project, they will seek an injunction. On what grounds? He cited something called equitable estoppel, claiming that your silence constituted implicit permission. I laughed. My silence? I never said they could build anything. He is arguing that you watched them build without objection, which implied consent. That is the dumbest thing I have ever heard. It is actually not unprecedented, but it requires several elements that do not apply here. I told him as much. Then I asked him to provide proof of ownership or legal right to the property. He said he would get back to me. How long before he realizes they do not have it depends on how thorough he is. A good title search would reveal the truth within a few days. If he is lazy or just trusts his client, could take longer. What do you think he will do when he finds out? Patricia was quiet for a moment. Honestly, he will probably try to find any loophole he can. These guys do not like to lose. But Xavier, the law is very clear here. You own the property. They built on it without permission. They are going to lose. But the amount of money involved means they will fight hard, and there are a lot of angry homeowners who are going to make your life difficult. I can handle it. I hope so. This is going to get worse before it gets better. She was right. Over the next 2 weeks, the harassment intensified. Karen filed a complaint with the county claiming I was interfering with permitted construction. When the county inspector came out, I showed him my property deed and survey. He took one look, made some notes, and left. 2 days later, the county suspended the HOA's permits pending title verification. That sent the HOA into a frenzy. Suddenly, construction stopped. The half-built pavilion sat unfinished. Dock number 40, which they had just started, remained incomplete. Tom, the contractor, stopped showing up. Karen showed up at my house 3 more times. The first time, she demanded I deed over the lakefront property to the HOA for fair market value. I declined. The second time, she offered to have the HOA pay me a yearly fee for an access easement. I declined. The third time, she just screamed at me from the driveway, calling me selfish, unreasonable, and a terrible neighbor before Richard dragged her away. The homeowners were no better. I started getting nasty letters in my mailbox. Someone egged my truck. A group of teenagers from the development came down to the lake one evening, and when I told them they were trespassing, they laughed and jumped off the docks anyway. I called the sheriff's department. When the deputy arrived, the kids scattered, but not before one of them shouted that I was a jerk who was ruining everything. The deputy, a middle-aged guy named Carlson, took my statement and then asked to see my property documents. I showed him everything. He nodded slowly. So this is all your land, every inch, and the HOA just built all this without permission. That is correct. Well, that is one hell of a mess, he said. You want to press charges for the trespassing, not against the kids. They did not know any better. But yes, I want it on record that people are trespassing on my property. Fair enough. I will file a report. You might want to put up some no trespassing signs, though. Makes it clearer. I took his advice and ordered professional signs the next day. When they arrived, I posted them every 50 feet along the shoreline. That triggered another visit from Karen, this time with Douglas Webb, the HOA's attorney. Webb was in his 50s, gray hair, expensive suit, and the kind of confident bearing that came from winning more cases than he lost. We sat in my living room, and he laid out his position. Mr. Thompson, my clients have invested over $300,000 into infrastructure that benefits the entire community. While I acknowledge there may have been an administrative oversight regarding the exact property boundaries, the reality is that these docks are built, they are valuable, and they serve a legitimate purpose. Administrative oversight, I repeated. They built on land they do not own. Property disputes are rarely black and white, Webb continued. There are principles of adverse possession, prescriptive easement, and equitable considerations that courts weigh in these situations. None of which apply here, I said. You cannot claim adverse possession after a few months. There is no prescriptive easement because I never granted permission. And there is nothing equitable about an HOA spending $300,000 without verifying they had legal right to build. A court might see it differently, particularly when the alternative is requiring the removal of valuable infrastructure that benefits dozens of families. That is not my problem. Karen, who had been sitting silently, finally spoke up. Why are you being so stubborn about this? We are offering to pay you. I do not want your money, I want my property respected. But you are not even using the lakefront, she protested. You have 800 feet of shoreline. What is the harm in sharing some of it? The harm is that it is mine. I bought it. I pay taxes on it. And I decide what happens with it. That is incredibly selfish, Deanne added. She had come along too, sitting primly on the edge of my couch looking offended by my very existence. It is called property rights, I said. You should look it up. Webb held up a hand. Let us try to be constructive here. Mr. Thompson, what would it take for you to grant an easement? There is no number. Everyone has a number. I do not. $500,000, he tried. The HOA could potentially finance that over time. No, $1 million. No amount of money will make me give up my property rights. If I let you get away with this, what is next? You decide you want to build a clubhouse on my land, a parking lot. Where does it end? Karen stood up abruptly. This is pointless. He is clearly unreasonable. Webb remained calm. Mr. Thompson, I want to be clear about what will happen if we cannot reach an agreement. The HOA will file suit seeking an easement by necessity, equitable relief, and possibly damages for your interference with a permitted project. This will be expensive, time-consuming, and unpleasant for everyone involved. Then file your suit, I said. I look forward to explaining to a judge how your client spent $300,000 without bothering to verify they owned the land first. Webb studied me for a long moment, then nodded. Very well, you will be hearing from us. They left, and I immediately called Patricia. They are going to sue. Good, she said. Let them. We will counterclaim for trespassing, damage to property, and injunctive relief requiring removal of all structures. How long will this take? Could be months, maybe a year. Depends on the court schedule and how hard they fight. They are going to fight hard. Then so will we. The lawsuit arrived 2 weeks later. The HOA was seeking a permanent easement across my property, claiming that denying access would create a hardship for 40 families who had relied on the representation that lake access was available. They claimed equitable estoppel, arguing that my failure to object to the construction constituted implied permission. They also claimed that removing the docks would be a waste of valuable resources, and that the court should impose an easement with compensation. Patricia filed our response, along with a counterclaim. We argued trespass, demanded removal of all structures, sought damages for unauthorized use of my property, and asked for attorney's fees. We attached the survey, the deed, the title report, and a complete history of the property showing that it had never been part of Lakeview Estates. The local newspaper got wind of the case and ran a story. Lakefront property dispute pits homeowner against HOA. The article made me sound like a hermit who was keeping families away from the lake out of spite. They interviewed Karen, who gave a tearful account of how the community had come together to build something beautiful, only to be stopped by one unreasonable man. They interviewed some of the homeowners too. A woman named Susan Martinez said her kids had been so excited to use the docks and now were heartbroken. A man named James Dalton said he had bought his house specifically because of the advertised lake access and felt deceived. The paper did interview me, but they only used one quote where I said, "The property is mine, and I did not give permission for this construction." Out of context, it made me sound cold and unfeeling. The story went semi-viral locally. I started getting hate mail from strangers. Someone started a Facebook group called Justice for Lakeview Estates that had over 500 members within a week. They posted pictures of the docks, called me names, and strategized about how to force me to give in. Emily came up again that weekend. She had seen the Facebook group and was worried. "Xavier, some of these people sound unhinged. They are talking about protesting at your house." "Let them protest," I said. "I am not backing down. I am not saying you should back down. I am saying be careful. People get weird about stuff like this." She was right to be concerned. The following Saturday, about 30 people showed up with signs. "Share the lake. Property rights do not mean heartless. Think of the children." They stood at the end of my driveway chanting. Deputy Carlson showed up to make sure things stayed peaceful. I watched from inside, refusing to engage. After about 2 hours, they got bored and left. But it was unnerving, having that many angry people focused on me. The preliminary hearing was set for late August, 3 months after the construction had stopped. Patricia and I met at the courthouse in Hayward. It was a small county courthouse, older building with dark wood paneling and high ceilings. Judge Martha Reynolds presided, a woman in her 60s with steel gray hair and a no-nonsense demeanor. Douglas Webb was there with Karen, Richard, and Deanne. There was also a representative from the HOA's insurance company, a nervous-looking man in a cheap suit who kept wiping his forehead with a handkerchief. Judge Reynolds called the hearing to order. "This appears to be a straightforward property dispute, but I have read both the complaint and the counterclaim, and there are significant issues to resolve. Mr. Webb, your clients claim an implied easement based on Mr. Thompson's silence during construction. Please explain." Webb stood. "Your Honor, the doctrine of equitable estoppel prevents someone from asserting a right when their silence has led others to rely on an implied permission. Mr. Thompson watched for months as my clients invested hundreds of thousands of dollars. He never objected, never warned them, never indicated there was any problem. Now, after all that investment, he claims trespass. That is inequitable." "Miss Chen," Judge Reynolds looked at Patricia. Patricia stood. "Your Honor, there is no implied permission here. Mr. Thompson was under no obligation to stop someone from making a mistake. The HOA had a duty to verify they owned or had rights to the property before building. They failed to do that. Equitable estoppel requires detrimental reliance on a statement or action. Mr. Thompson made no statement and took no action that would have led anyone to believe he consented." "He watched them build for months," Webb interjected. "Watching is not consent," Patricia shot back. "If I watch my neighbor build a fence 6 inches onto my property, my silence does not give them the right to keep it there. Property rights do not evaporate because someone builds something without permission." Judge Reynolds held up a hand. "I have reviewed the property documents submitted by Mr. Thompson. They appear to be in order. Mr. Webb, do you have any documents showing your clients own or have rights to this property?" Webb hesitated. "Your Honor, we are still conducting title research, but the original development plat shows—" "I have seen the plat," the judge interrupted. filed in 2019. What I have not seen is any proof that the developer owned the lakefront property when that plat was filed, or that the property was ever properly conveyed to the HOA. The homeowners were told lake access was included, Webb tried. What homeowners were told and what is legally true are two different things. Do you have a deed, Mr. Webb? An easement? Any recorded document that gives your clients legal right to build on Mr. Thompson's land? The silence stretched out. Webb glanced at his clients, then back at the judge. Not at this time, Your Honor. Then we have a problem. You are seeking an equitable remedy for a situation your clients created by failing to do basic due diligence. That is not a strong position. Your Honor, Karen suddenly spoke up. Webb tried to stop her, but she was already standing. This is not about legal technicalities. This is about 40 families who deserve access to the lake. My community came together and built something beautiful. We should not be punished because of one property line dispute. Judge Reynolds looked at her coolly. Mrs. Hollingsworth, is it? Yes, Your Honor, Mrs. Hollingsworth, property lines are not technicalities. They are the foundation of property law. You built extensive structures on land you do not own. That is not a minor oversight. That is trespass. But we did not know, Karen protested. Ignorance is not a defense. You had a responsibility to verify ownership before spending $300,000. You failed to do that. So he just gets to keep all our docks, Richard blurted out. We should at least be compensated for the value of the construction. Judge Reynolds turned to him. Are you suggesting Mr. Thompson should pay you for structures you built on his land without permission? They add value to his property, Richard argued. That is not how this works. If I build a garage on your property without permission, you do not owe me for the garage. Patricia stood again. Your Honor, we are seeking removal of all structures as part of our counterclaim. Webb jumped in. Your Honor, requiring removal would be a tremendous waste. Those docks are worth hundreds of thousands of dollars. Should have thought of that before building them on someone else's land, Judge Reynolds said dryly. However, I am not making any final rulings today. This is just a preliminary hearing. We will have a full trial in November. Between now and then, I strongly suggest the parties try to reach a settlement, because if this goes to trial, somebody is going to walk away very unhappy. We have tried to settle, Webb said. Mr. Thompson refuses to negotiate. Mr. Thompson has no obligation to negotiate. He owns the land. You built on it without permission. The law is on his side. If there is going to be a settlement, it will be on his terms, not yours. Karen made a strangled sound. Deanne put a hand on her arm. Judge Reynolds looked at me directly for the first time. Mr. Thompson, I understand you are within your legal rights, but I have to ask, is there no compromise possible here? These families genuinely believed they had lake access. They invested significant money. Is there no arrangement you would consider? I stood up. Your Honor, with respect, if I compromise now, I am rewarding bad behavior. The HOA did not make a small mistake. They spent months building on my land without even checking if they had the right to do so. If I let them keep even a single dock, I am setting a precedent that property rights do not matter as long as you spend enough money and claim you did not know better. So your answer is no. My answer is that they need to remove everything they built, restore my property to its original condition, and accept that actions have consequences. Judge Reynolds nodded slowly. Very well. Trial is set for November 15th. I expect both parties to come prepared with complete documentation. This hearing is adjourned. We filed out of the courtroom. In the hallway, Karen confronted me immediately. You are destroying this community. No, you destroyed it when you spent $300,000 without doing your homework. "Those families trusted me," she said, and for the first time I saw genuine distress in her eyes. "They trusted the board. We told them they would have lake access. Now they think we lied to them." "You did lie to them. Maybe not intentionally, but you made promises you had no right to make." "What do you want from us?" Deanne asked. "Seriously, what would make you happy?" "I want my property back the way it was." "So 40 families just lose their investment. Kids do not get to enjoy the lake, all because you want to prove a point." "All because I own the land, and nobody asked me if they could use it." Richard stepped forward, his face red. "You could have stopped this on day one. You could have said something, but you let us build everything and then pulled this legal ambush. You are not some innocent victim here." "I did not tell you to build on my land. You made that choice. You let us think we could." "I did not let you think anything. You assumed, and you were wrong. That is on you." Douglas Webb put a hand on Richard's shoulder. "Let us go. This is not productive." As they walked away, Patricia turned to me. "That went well. The judge sees through their nonsense. She does. But she is also hinting that you should settle. Judges do not like property destruction, even when it is justified. She might rule in your favor but not give you everything you want." "What do you mean?" "She might let you keep the docks but award them compensation for unjust enrichment. Or she might require them to remove some structures but not all. Or she might impose a limited easement with significant restrictions and fees. There are a lot of ways she could split the baby." "I do not want to split the baby. I want my property back." "I know, but be prepared for the possibility that you do not get exactly what you want." That night, I stood on my dock, the one I had built when I first bought the property, and looked at the HOA's construction. 40 docks stretched down the shoreline, some simple floating platforms, others elaborate structures with built-in benches and solar lights. In the fading light, I had to admit they were well constructed. Tom the contractor had done good work, but they were still on my land. And that was the only thing that mattered. The months leading up to trial were tense. The HOA tried several more settlement approaches. They offered to remove half the docks if they could keep the other half. I said no. They offered to pay me $50,000 a year for an easement. I said no. They offered to buy the entire lakefront property for twice what I paid for it. I said no. Each rejection made them angrier. The online harassment intensified. Someone found my work email and sent messages to my employer claiming I was unstable. My boss called me, confused, and I had to explain the whole situation. Fortunately, he found it amusing and told me not to worry about it. Someone slashed my tires one night. Deputy Carlson took a report but said without witnesses or cameras, there was nothing he could do. I installed security cameras after that. The HOA held a special meeting to discuss the situation. I was not invited, but Emily went undercover, claiming to be considering buying a house in the development. She reported back that the meeting was chaotic. "Karen basically broke down crying," Emily told me. She admitted they never did a proper title search because the developer assured them the lake access was included. Several homeowners demanded to know why the board was so incompetent. One guy said they should all resign. Another guy said they should keep fighting you no matter what it costs. What was the consensus? They voted to continue pursuing the case but also voted to remove Karen as president after the trial ends. She is basically being scapegoated. She should be. This was her project. "I almost feel bad for her," Emily said. "I mean, she screwed up big time, but she clearly thought she was doing something good for the community. The road to hell is paved with good intentions." That is very cold, Xavier. It is reality. She made assumptions, did not verify them, and now people are suffering because of it. Feeling bad does not change that. November arrived with cold winds and gray skies. The trial was set for a Monday, and Patricia told me it would probably last 2 or 3 days given the amount of evidence and number of witnesses. The courtroom was packed. Dozens of homeowners from Lakeview Estates showed up, filling the gallery. I recognized many of them from the protest. They glared at me as I walked in with Patricia. Judge Reynolds took the bench and reviewed the case summary. We are here to determine ownership and rights to approximately 800 feet of lakefront property on Mirror Lake. The defendant and counterclaimant, Xavier Thompson, claims sole ownership. The plaintiff, Lakeview Estates HOA, claims an implied easement or, alternatively, seeks equitable relief allowing them to maintain structures built on the disputed property. Let us begin with opening statements. Douglas Webb stood first. Your Honor, this case is about fairness and equity. My clients acted in good faith, relying on representations from the development's original owner that lake access was part of the community amenities. They obtained county permits, hired licensed contractors, and built high-quality structures that have benefited dozens of families. Mr. Thompson watched this entire process, said nothing, and now seeks to unjustly enrich himself by keeping these structures while forcing my clients to absorb the loss. We ask the court to impose an equitable easement that protects the HOA's investment while fairly compensating Mr. Thompson. Patricia stood. Your Honor, this case is actually quite simple. Mr. Thompson owns the property. He has a clear deed, a professional survey, and title insurance confirming his ownership. The HOA built on his land without permission, without verifying ownership, and without any legal right to do so. That is trespass. The law provides a clear remedy: removal of the trespassing structures and restoration of the property. My client is asking for nothing more than what the law already guarantees him. Judge Reynolds nodded. Mr. Webb, call your first witness. Webb called Karen Hollingsworth. She took the stand looking nervous but composed. After being sworn in, Webb led her through the background. Mrs. Hollingsworth, please explain how this dock project came about. In 2025, several homeowners approached the board about adding lake access. When people bought homes in Lakeview Estates, they were told that lake access was one of the community features. But there was no actual way to access the lake. We had to walk through Mr. Thompson's property, and we did not feel comfortable doing that without formal permission. So you initiated the dock project? Yes. We hired a consultant who reviewed the development plat and confirmed that lake access was designated as common area. Based on that, we moved forward with planning. Did you attempt to contact Mr. Thompson? Yes. I met with him in March of 2026 and explained the project. He said he would think about it. And did he ever say no? Not in so many words. He just never responded, but he watched us build everything. He had to know what we were doing. Patricia stood for cross-examination. Mrs. Hollingsworth, when you met with Mr. Thompson in March, did he sign any documents? No. Did he give you verbal permission to build? Not explicitly, but yes or no, Mrs. Hollingsworth, did he give you permission? No. Did you or anyone on the HOA board conduct a title search before beginning construction? Karen hesitated. We reviewed the development plat. That is not what I asked. Did you conduct a title search? Not formally, no. Did you contact a title company? No. Did you hire a real estate attorney to verify ownership? No. So you spent $300,000 building structures on land without verifying who owned it. We relied on the development plat and the representations from the original developer. When did the original developer, Michael Patterson, make these representations? When the community was first established in 2019. And did you verify whether Mr. Patterson still owned the lakefront property at that time? I assumed he did since he was selling lots. You assumed. Did you verify? No. Were you aware that Mr. Patterson declared bankruptcy in 2014? I learned that later, yes. After you built the docks? Yes. So you never verified ownership, never got written permission, never conducted due diligence, and simply assumed you had the right to build on Mr. Thompson's land. Is that accurate? Karen's face flushed. We were trying to do something good for the community. That was not my question. Is my summary accurate? Yes, Karen said quietly. Patricia let that hang for a moment. No further questions. Webb called several homeowners next, each testifying about how they relied on the promise of lake access when buying their homes, how their families enjoyed the docks during the brief time they were accessible, and how devastating it would be to lose them. It was emotionally compelling but legally irrelevant, and Patricia did not bother with extensive cross-examination. Then, Webb called a real estate appraiser, who testified that the docks added approximately $400,000 in value to my property. The implication was clear. I was being unjustly enriched. Patricia handled this on cross. Mr. Burke, is it correct that property owners generally have the right to improve their own property? Yes. And if I build a deck on my property, I do not owe my neighbor compensation even if it makes my house more attractive and potentially impacts neighborhood values. Correct. So the fact that these docks might add value to Mr. Thompson's property is irrelevant if he did not ask for them and did not give permission to build them. Burke shifted uncomfortably. Well, there is a doctrine of unjust enrichment, which requires that the enrichment be unjust. If someone builds something on my land without permission, and I want it removed, how is it unjust for me to keep what is on my land? I am an appraiser, not a lawyer. Exactly. No further questions. The first day ended with Webb calling Tom Sanderson, the contractor. Tom testified about the quality of construction, the care taken to meet all environmental regulations, and the total cost of the project. He seemed uncomfortable, probably realizing he had built a $300,000 project without verifying his client owned the land. Day 2 began with Patricia presenting our case. She called a surveyor who walked through the exact property boundaries, showing on a large map exactly where my property began and ended. Every single dock was within my property lines. She called the title company representative who had handled my purchase. He confirmed the chain of title, explaining how the property had gone through bankruptcy court and was sold separately from the rest of the development land. Then, Patricia called me. I testified about buying the property, my initial meeting with Karen, and my decision to document everything rather than immediately object. Webb's cross-examination was aggressive. Mr. Thompson, you admit you watched the construction for months without saying a word. Yes. You could have stopped this on day 1, correct? I could have. But you chose not to because you wanted to trap the HOA into spending as much money as possible. I wanted to see if they would actually go through with building on my land without permission. I wanted clear evidence of their trespass. That is vindictive, is it not? It is strategic. If I had stopped them immediately, they would have claimed it was just a misunderstanding. By letting them complete the project, I have clear evidence of deliberate trespass. These are families, Mr. Thompson, people with children who just wanted to enjoy the lake. These are people who could have bought lakefront property if they wanted guaranteed access. They chose to buy homes in a development and rely on their HOA to deliver amenities. That is not my problem. You really think 40 families should lose their investment because of a property line? I think property rights matter. If the law does not protect my right to control my own land, then what is the point of ownership? Webb tried several more angles, but I refused to budge. I was not going to apologize for asserting my legal rights. Patricia's final witness was a restoration contractor who testified it would cost approximately $60,000 to remove all the docks and restore the shoreline to its natural state. Webb objected to the relevance, but Judge Reynolds allowed it. Closing arguments took most of day 3. Webb made an impassioned plea for equity, arguing that the HOA had acted in good faith and that destroying $300,000 worth of infrastructure would be a waste that benefited no one. Patricia was clinical and precise. She walked through the elements of trespass, showed that every element was satisfied, and argued that property law existed precisely to prevent what the HOA had done. She asked for removal of all structures, restoration costs, and attorney's fees. Judge Reynolds took a brief recess and then returned with her ruling. The courtroom went silent. I have reviewed all the evidence and testimony in this case. The law here is clear. Mr. Thompson has proven ownership of the disputed property through valid deed, survey, and chain of title. The HOA has provided no evidence of ownership, easement, or any legal right to build on that property. Therefore, Mr. Thompson's counterclaim for trespass is valid. Karen made a choking sound. Several homeowners in the gallery gasped. The question then becomes what remedy is appropriate. The HOA argues for equitable relief, claiming that removal would be wasteful and unjust. However, equity does not protect those who create their own problems through negligence. The HOA had every opportunity to verify ownership before building. They chose not to. They took the risk and they lost. Therefore, I am ordering the following. First, the HOA must remove all structures from Mr. Thompson's property within 90 days. This includes all 40 docks, the partial pavilion, the beach sand, and any other improvements. Second, the HOA must restore the shoreline to its natural state at their expense. Third, the HOA must pay Mr. Thompson's attorney's fees and court costs. Fourth, the HOA is permanently enjoined from trespassing on Mr. Thompson's property or claiming any rights to it. She paused and looked directly at Karen. Mrs. Hollingsworth, I want to be clear. This outcome was entirely preventable. A single title search would have revealed the truth. Your failure to exercise basic due diligence cost your community $300,000. That is on you and your board, not on Mr. Thompson. She banged her gavel. This court is adjourned. The courtroom erupted. Homeowners were crying, shouting, demanding answers. Karen sat frozen at the plaintiff's table, tears streaming down her face. Richard was arguing with Webb, who was shaking his head. Deanne had her face in her hands. Patricia and I left quickly, avoiding the crowd. Outside, she shook my hand. Congratulations. Total victory. How long before they appeal? They might try, but they have no grounds. The law was clearly on our side, and the judge's ruling was sound. An appeals court would almost certainly affirm. So this is really over. This is really over. That night, I sat on my deck and watched the sunset over Mirror Lake. The HOA's dock stretched out before me, silent and empty. Soon they would be gone, and my shoreline would return to the way it was meant to be. Emily called. I saw the news. You won. I did. How do you feel? Relieved, vindicated, a little sad, actually. Sad. Those families genuinely thought they were getting something they paid for. They trusted their HOA, and the HOA failed them. I do not feel bad about winning, but I do feel bad that this happened. That is very human of you. I am not a monster, Emily. I just believe in property rights. I know. Are you going to have any problems with the community now? Probably. But I will deal with it. The removal process took the full 90 days. Tom Sanderson's crew came back, this time to tear down what they had built. It was depressing to watch, all that work undone. But it was necessary. True to the timeline, the HOA appealed. Their appeal was denied within 6 weeks. The appellate court issued a brief ruling stating that the trial court had correctly applied the law and that the HOA's arguments lacked merit. The financial impact on Lakeview Estates was severe. The HOA had to take out a loan to cover the removal costs and my attorney's fees. Several homeowners sued the HOA board members personally for mismanagement. Karen, Richard, and Deanne all resigned and were replaced by new board members who immediately hired a lawyer to go after the original developer for misrepresentation. Michael Patterson, the original developer, had apparently told the HOA that lake access was included when he knew it was not. The new board filed suit against him for fraud. I heard through the grapevine that they eventually settled for $150,000, which helped but did not come close to covering their losses. The harassment eventually died down. People moved on to other dramas. The Justice for Lakeview Estates Facebook group became inactive. My tires were no longer slashed. About a year after the judgment, I got a letter from the new HOA president, a man named Marcus Chen, who seemed much more level-headed than Karen. He wrote, "Mr. Thompson, I want to apologize on behalf of the Lakeview Estates HOA for the way you were treated during this dispute. The previous board made serious errors in judgment, and you were unfairly vilified for asserting your legal rights. While we are disappointed with the outcome, we accept that the law was on your side and that our community must bear the consequences of poor leadership. We hope that relations between the HOA and you can be cordial going forward. We have no intention of pursuing any further claims regarding your property and ask only that if you ever decide to grant lake access or sell any portion of your land, you will consider offering it to the community first. Thank you for your patience during a difficult time." It was a classy letter, and I appreciated it. I wrote back thanking him and saying I would keep the community in mind if my circumstances ever changed. I did not commit to anything, but I could be gracious in victory. 2 years after the trial, I was still living on Mirror Lake. The shoreline had returned to its natural state, wild and beautiful. I built a small boathouse for my kayak and a fire pit where I sometimes sat in the evenings. Emily and I had gotten engaged, and she moved up from Chicago. She worked remotely too, and we made a good life together on the lake. The neighborhood eventually accepted us, or at least stopped actively hating us. One evening, we were sitting by the fire when Emily asked, "Do you ever regret how you handled this?" I thought about it. "No, I did what I had to do. Property rights are not negotiable." "But $300,000, Xavier, that is a lot of money down the drain." It was not my money, and it was not my mistake. The HOA made a choice to build without verifying ownership. They gambled and lost. If I had let them keep the docks, what message would that send? That you can trespass as long as you spend enough money and claim ignorance? I guess not. Property rights are the foundation of our legal system. If those do not mean anything, then nothing means anything. She leaned against me. "You are very principled. I am very stubborn." That too. We sat in comfortable silence, watching the fire burn down to embers. Across the lake, lights twinkled from the houses in Lakeview Estates. Somewhere over there, families were living their lives, probably having moved on from the dock controversy. But I would never forget. I would never forget watching Karen Hollingsworth direct workers to build on my land without permission. I would never forget the arrogance of the HOA assuming they could take what was mine. I would never forget standing in that courtroom and watching Judge Reynolds confirm that property rights still mattered. Some people might call what I did vindictive or excessive. They might say I should have been more neighborly, more willing to compromise. But those people do not understand what it means to own something, really own it, and have someone try to take it from you. The HOA thought they could bully me into submission. They thought I would cave under social pressure or legal threats. They thought wrong. I let them build 40 docks on my lake without saying a word. I documented every nail they hammered, every board they installed, every dollar they spent. And then, when they were fully committed and could not back out, I showed the judge my property deed and watched their entire project collapse. It was the most satisfying legal victory of my life, and I would do it again in a heartbeat. Years later, I would still occasionally see Karen Hollingsworth in town. She never acknowledged me, and I never acknowledged her. We both knew what had happened. We both knew who won. My property remained mine, as it should be. The HOA learned an expensive lesson about due diligence and property rights. And I learned that sometimes the best revenge is not immediate confrontation, but patient documentation followed by decisive legal action. The lake was quiet now, restored to its natural beauty. My 800 feet of shoreline belonged to me and me alone, exactly as the law intended. And every time I looked out at that pristine water, I felt a deep satisfaction knowing that I had stood up for my rights and won. Property rights matter. Ownership matters. And no HOA, no matter how entitled or well-funded, can change that fundamental truth. That is my story. That is how I let an HOA build 40 docks on my lake without saying a word, and then showed the judge my property deed. It was not mercy or patience that kept me silent during those months of construction. It was strategy. And in the end, strategy won.